Hello everyone, welcome to the last section in the pre-litigation module on the ULV Justice Center website. Very pleased to have you. In this video, I'll be talking to you about what a demand letter is and what next steps you are recommended to take after this phase. Before we start, I just wanted to give you a quick reminder that the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. Let's get into what exactly a demand letter is and what it entails. In simple terms, a demand letter is just that, a formal letter that details your demands to the opposing party, which includes all liable parties. As you have already completed the previous steps of gathering the facts, conducting a simple investigation, calculating your specific damages, and creating a legal analysis, it is now time to tie all four of those steps into a demand letter. It is very important to know when and how to use a demand letter, as it is not common to create one for every single case. Because a demand letter is most common in civil disputes, it is a strategy that can be used by you to have the opposing party either take or stop a certain action, meaning that your demands may be monetary or not, depending on your specific case and the damages you have calculated. You may be in a situation where you are asking the person you are suing to either pay you the amount you have calculated, to complete a previous action they have promised you to do, or to stop them from completing further actions they have done to you. In most cases, demand letters are used to demand an amount that you will settle on so that this matter will not have to go to court. It can also serve as a point on where to start negotiating. First, let's talk about what a demand letter needs and how it is structured. This letter needs to be typed and printed out as it is a professional document. As a side note, you should also keep a copy of the letter for your records. On our website, we have a page dedicated to writing a legal letter. I highly suggest you go check that out, as the speaker goes into a more detailed voiceover of all the things a legal letter can include, as well as on the demand letter section of this module. I have included a template for a demand letter that you can fill out. For right now, I will just give you an overview. The very first thing you should do is format your letter. A simple format includes a font of size 12 and Times New Roman. The spacing can be singled or at the 1.15 measurement, given your preference. The first thing you will type is the date you are sending this letter. As shown in the PowerPoint, the format should be month, day, then year. Then skip a line and on the next line, type in the name of who you are sending it to, the company name if you are suing a company, their full address as well. You may send this letter either to the person or persons you are directly suing or their attorney if you happen to know their information. Now that you have done that, you can skip at least one more line and type in the typical greeting of Dear Mr., Miss, or Mrs. followed by their last name. The body of the letter needs a great amount of information, all while keeping the letter at least one page to keep the attention of whoever you are sending it to. The body should be divided into 3 different sections. The first section should be a simple introduction of what this letter is about. It should explain the letter's purpose. For example, I am writing to you today in an effort to resolve a negligence claim without litigation. This gives the recipient a short review of what this letter is about and lets them know you are reaching out to them with your demands. Then on to the second section where you need to detail the most important facts about what happened to you. You need to include not only the facts, but also the evidence you have, as well as certain facts that help back up the damages you are demanding. Start with the date of the incident, then go on to the facts. For example, on April 5th, 2020, I went to a restaurant with my family for dinner. Our waiter was not attending to us in a friendly manner, constantly rolling their eyes and showing signs of annoyance. I asked our waiter, Mr. Smith, if he had a problem, and we got into a little disagreement. When our drinks came out, I began to drink it, but when I looked closer to the top of the drink, I found some bodily fluids that very clearly was spit. Using our scenario, let's say that the person contracted an STD from the saliva they unknowingly drank. That would need to be in the letter saying that they have medical records and their doctor can attest to them contracting the STD from that disgruntled employee. Make sure to cite any law that you include with proper citation. For example, using our scenario, according to the California Civil Code Section 1714, your employee is responsible for their willful acts as well as an injury to another by their ordinary care or skill. It is also a good idea to write out a brief summary of your legal analysis. Recall that you don't want to give everything away to your opposing party, but a summary lets them know that you know what you're doing, and it also gives them a reason as to why they will lose if they deny your demand letter. Include the amount of damages you are demanding and the reasons as to how you calculated that number. You don't have to give them a breakdown behind your damages, just a simple explanation of what you have suffered. Remember, not every demand letter asks for money, so your letter can take a whole different direction. It all depends on your case. The last section of the letter is the conclusion. This is the part where you let them know if what you are asking for is not met, you will have to take legal actions to settle your claim. You will also need to put a deadline with a set date they have until to respond with an answer. Make sure to include your contact information, such as your phone number and email, so that they may reach you if they don't want to send a formal letter back with their answer. For example, a closing can include, "This letter serves as a pre-litigation courtesy in an attempt to resolve this claim outside of a court of law. Otherwise, I will have to take proper legal action to settle my dispute. Please contact me within 15 days of the date of this letter to discuss this matter. If you have any questions or concerns, please contact me through my phone number 636-532-7865 or my email, which is leo.martinez@gmail.com. Lastly, sign off with the sincerely and your full name at the end. You have the option of leaving a space big enough between the sincerely and your name so that you may sign your name after you have printed the letter. Make sure to include spacings between the three different sections of the body of the letter, as it gives it a cleaner look. Before printing the letter, make sure you have proper spelling, punctuation, and grammar. You may want to take the extra step of having someone review it for you if you choose to. Now that you have completed the actual step of writing the letter, let's talk about a timeline. Typically, a demand letter is sent right before you decide to file a complaint. Sending a demand letter can set a critical point of whether you will have to take your case to court or settle your case outside of court. It is not a mandatory requirement to send out a demand letter in order to file a complaint. If you believe the opposing party will certainly deny your demands, then you can still file the complaint even before receiving a response. But if you think they will settle out of court with you, it is best to wait for a response, as it will save you from the filing fee you have to pay when you file a complaint. The minimum amount of days you should give the opposing party is 15 days, so that they may have enough time to receive the letter through U.S. mail and a chance to think it over and come to a decision. If the opposing party denies your demands, then you can make the choice of proceeding to file a complaint. If they accept, then you can continue directly communicating with them either by yourself or with a lawyer to better represent yourself. When setting the deadline of how long they have to respond, it is important to remember the statute of limitations for your case. A statute of limitations is a law that varies from different states and causes of actions. They are deadlines, so to speak, when you are allowed to bring forward a claim. For example, in California, the statute of limitations on a case that has a cause of actions of negligence on malpractice from a doctor has a limit of 1 year. So, a malpractice claim must be filed within 1 year from the date of which the incident happened or when it was discovered there was an injury. You can easily Google the statute of limitations for your case in your state if you are worried you have run out of time. So, knowing the amount of time you have left to file a claim can also determine how much time you will give the opposing party to respond to your letter. To conclude this section, the purpose of a demand letter is to give both parties a chance to communicate and possibly settle the issue before taking the steps to bring this matter into court. A demand letter is used to tell the opposing party what you are requesting and the why behind the demand. The opposing party needs a clear understanding of a review of what happened, what you are asking for, a reason behind your demands, whether they are monetary or not, a timeline of how long they have to respond back that gives them a chance to determine if settling out of court can save them time and resources. If you decide not to send a demand letter and jump right into filing a complaint, you may run the risk of not winning in court when there might have been a great chance that the opposing party saw the advantage of settling outside of court. It does not hurt to ask, and if the demand is accepted, it can speed up the process of having your problems settled and your demands met. The opposing party may deny or accept your demands, and writing a proper letter can help the opposing party make that decision. This has been an overview of the demand letter section in the pre-litigation module On behalf of the U of V Justice Center, we thank you for your time and hope this information is helpful in your legal matter.